Good day, everyone. My name is Rechell Cinas, and for this subject, legal aspects and tourism and hospitality, the topic that I will tackle is about laws related to tourism, investments, and finance. Chapter 12. For the learning objectives is to enumerate the procedure in setting up a tourism-oriented business, explain the laws governing tourism investments and financing tourism-oriented projects, discuss the business models applicable to tourism projects, enumerate the various taxes application to tourism-related establishments, discuss the limitation of foreigners in tourism investments. Now, this chapter focuses on promoting, monitoring, and regulating tourism investments in the country. It highlights the importance of the private sector, including foreign investors in the tourism industry. Special laws cater to specific sectors such as the informal sector of Filipino balikbayans, retirees, and senior citizens, providing incentives for investment. Now, for Foreign Investments Act of 1991, number 1, a Philippine national refers to a citizen domestic partnership or corporation meeting specific ownership criteria. Small, medium-sized enterprises with less than 200,000 US dollar in paid-in equity capital are reserved for Philippine nationals. Number 3, non-Philippine nationals may be allowed if they involve advanced technology or employ at least 50 direct employees with a minimum paid-in capital of 100,000 US dollar. Then number 4, doing business includes various commercial activities such as soliciting orders, opening offices, appointing representatives, and participating in management or control of domestic entities. Number 5, mere investment as a shareholder by a foreign entity in registered domestic corporations without engaging in commercial activities is not considered doing business. Now, let's dive into the discussion of the Foreign Investment Act of 1991 and its implication for foreign investors in the Philippines. Firstly, the Foreign Investment Act of 1991 opens up the Philippine market to foreign investment in almost all sectors except those outlined in the negative list. This means ang mga foreigners maka-invest in various activities and enterprises provided they complied with the regulations. One key aspect is distinguishing between domestic market enterprises and export enterprises. So domestic market enterprises cater primarily to the local market, while export enterprises focus on exporting a significant portion of their output. Now, in domestic market enterprises, foreigners can typically invest up to 100% equity with exceptions outlined in a negative list. But kung ang paid-in equity capital is less than $200,000, the US dollar, the enterprises is reserved for Philippine nationals unless it involves advanced technologies or employs at least 50 direct employees, in which case non-Philippine nationals can invest with a minimum paid-in capital of $100,000. So, export enterprises have no restrictions on foreign ownership, allowing up to 100% equity unless they fall within negative list A and B or utilize raw materials from depleting natural resources. Now, we talk about the registration process. Foreign nationals or entities not seeking incentives under the Omnibus Investment Code must file for registration with the appropriate authorities. So, corporations and partnerships registered with the Securities and Exchange Commission or SEC, while single or sole proprietorship registered with the Bureau of Trade Regulation and Consumer Protection or BTRCP of the Department of Trade and Industry. Now, failure to comply with the registration requirements or secure the necessary SEC license can result in administrative sanctions like fines, forfeiture of benefits, and even criminal liability for foreign corporations. Additionally, failure to comply may impact a foreign corporation's ability to sue or be sued in the Philippine courts. Investment in travel agencies and tour operators. The following may apply for accreditation as tour operators. A resident Filipino citizen. B, a partnership organized under the laws of the Philippines, at least 60% of its capital being owned by Filipino citizens. And C, corporations organized under the laws of the Philippines, at least 60% of the subscribed common or voting shares of stocks of which is owned by Filipino citizens, and the composition of its board of directors being at least 60% Filipinos. Now, thirdly, let's unpack the limitations on foreign participation in the accreditation and operation of travel agencies and tour operators in the Philippines. As outlined in Memorandum Order number 211 or 211 and the Omnibus Investment Code of 1987. So, according to Memorandum Order, which approves the 2006 Investment Priorities Plan, tourism-related activities including travel agencies and tour operators are classified as preferred activities. This classification means that these activities are prioritized for investment incentives and support. However, there's a catch. For a travel agency or tour operator to be eligible for registration under the Investment Priorities Plan, the applicant must satisfy certain criteria set by the Board of Investments. Firstly, the applicant must be a citizen of the Philippines. If they are a natural person or if they are a partnership corporation or cooperative, they must be organized under Philippine laws. Additionally, at least 60% of their capital or capital stock must be owned and controlled by the Philippine nationals. And at least 60% of the members of the board of directors must be Filipino citizens. Now, secondly, the applicant must propose to engage in a preferred project listed or authorized in the current investment priorities plan within a reasonable time frame set by the board. Lastly, the applicant must demonstrate the capability to operate soundly and efficiently, contributing to the national development of the preferred area and the overall national economy. So now these requirements reflect the government's aim to promote local participation and control in key sectors like tourism while still encouraging investment and development. It ensures that the benefits of tourism-related activities are shared among Filipino citizens and contribute to the country's economic growth. For the next slide, we have investment in hotels, resorts, and other accommodation establishments. By reason of the enactment of Memorandum Order number 211 or 211 approving the 2006 investment priorities plan of April 4, 2006, tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Tourism covers the development of tourism economic zones, tourist estates, eco-agritourism facilities, and the establishments of tourist accommodation facilities like hotels, resorts, and other tourism accommodation facilities such as apartments, pensions, houses, tourist inns, and similar establishments. For the next slide, application of the retail trade law for restaurants and shops. Restaurants and other tourism-related establishments such as department stores and shops are governed by the laws on retail trade by reason of the nature of their business, and the past operation and ownership of these establishments are confined only to Filipino citizens or to corporations and associations fully owned by Filipino citizens. By reason of the enactment of the Retail Trade Liberalization Act of 2000, foreign investors may now engage in retail trade subject to capital requirements. It refers to the Chapter 10 laws regulating restaurants and other tourism-related establishments. Now, talking about the exemptions under the Retail Trade Liberalization Act of 2000, which allow 100% foreign ownership participation in certain sales transactions. Firstly, sales transactions by manufacturers, processors, laborers, or workers to the general public are exempted if their capital does not exceed 100,000 pesos. This exemption aims to support small-scale local producers by allowing them to sell their products directly to consumers without restrictions on foreign ownership. Secondly, manufacturers are exempted from the restrictions regardless of their capitalization when selling their products in a single outlet. This exemption encourages direct sales by manufacturers, promoting efficiency and competitiveness in the retail sector. Lastly, sales in restaurants that are incidental to the hotel business are also exempted. This exemption recognizes the integrated nature of hotels and restaurants and allows foreign investors to fully own and operate such establishments, contributing to the growth of the hospitality industries. These exemptions reflect the government's effort to balance the promotion of local business with the attraction of foreign business, ultimately aiming to foster economic growth and development in the retail and hospitality sector. Applicable, negotiable instruments and documents of the title. By way of introduction, the laws applicable for purposes of discussion of the different negotiable instruments and documents of title and tourism investment are as follows. Number 1, Act of 2031, also known as the Negotiable Instruments Law. Number 2, Presidential Decree number 115, providing for the regulation of trust receipts transactions. Number 3, Warehouse Receipt Law Act of 2137. The following are some negotiable instruments and documents of title which can be useful in tourism financing and investment. Now we have the promissory note. It is a written promise committing the maker to pay a specified sum of money either at demand or at a fixed or determinable future date with or without interest. We have the special types of promissory notes. We have certificate of deposit, mortgage note. Then the bill of exchange, it is an unconditional order in writing addressed by one person to another, signed by the person giving it, require the person to whom it is addressed to pay on demand or at a fixed determinable future time a sum certain in money to order or bearer. Now the types of bills of exchange, we have draft, trade acceptance, and banker's acceptance. Now we have check. A check is a bill of exchange drawn on a bank payable on demand. Special types of checks, we have the manager's checks, the traveler's check, certified check, cruise check. Now talking about negotiable instruments and documents of title relevant to tourism, financing, and investment, firstly we have the promissory note, again, which is written in promise to nga mobayad ka in a specified sum of money either on demand or at a fixed future date. Sa atong special types include the certificate of deposit issued by the bank to acknowledge receipt of money on deposit, and the mortgage note, which gives the lender a lien on property as security for a loan. Next, we have the bill of exchange. Is an unconditional order to pay a sum certain in money to another party. These types include the draft, trade acceptance, again, and banker's acceptance, which are used in various commercial transactions including international trade, financing. Now moving on to checks, there are bills of exchange drawn on a bank payable on demand. Special types of include the manager's checks drawn by a bank manager upon the bank itself, and the traveler's check, which provides a safe and convenient method for travelers to carry funds. Additionally, we have the certified check guaranteed by the jury bank for payment upon presentation, and the cross check, which bears two parallel lines diagonally indicating restrictions on encashment and negotiation. These negotiable instruments play a vital role in facilitating transactions and financing in the tourism industry, whether it is providing funds or investments in tourist accommodations or facilitating payments between businesses and travelers. Understanding these instruments is crucial for effective financial management and investments in tourism-related ventures. Moving on, we have the Special Economic Zone Act of 1995, Republic Act 7916. The law establishes the legal framework for special economic zones, or SEZs, in the Philippines, administered by the Philippine Economic Zone Authority, or PIZA. The Department of Tourism, DOT, collaborates with PIZA to grant SEZ status to tourism and development zones, and states SEZ cater to tourist-oriented enterprises focused on serving foreign tourists as the primary clientele upon registration with PIZA and issuance of required presidential proclamation. Now, talking about incentives available for tourism-related business in the Philippines, up to 100% foreign ownership of the locator enterprises encourages foreign investments in tourism. Income tax holiday, or ITH, for 6 years for pioneer firms and 4 years for non-pioneer firms, with an extended ITH for business in less developed areas. Reduces tax burdens during initial years. Option to pay a special 5% tax on gross income after the ITH period. Simplifies taxations, tax and duty-free importation of capital equipment, facilitates acquisition of necessary assets. Special investors, resident visa, and provisions for employment of foreign national attracts foreign investors. Additional incentives determined by the Philippine Economic Zone Authority, or PIZA, board provide flexibility to support tourism industry growth. These incentives collectively create an attractive investment environment, promoting economic development and competitiveness in the Philippine tourism sector. Lastly, we had the Barangay Micro Business Enterprises Law. The Barangay Micro Business Enterprises or BMBS Act of 2002, Public Act 9178 aims to promote economic development by supporting small-scale businesses, integrating them into the formal economy and providing incentives for growth. BMBS are small enterprises engaged in various activities with total assets not exceeding 3 million pesos excluding land. Eligible entities can apply for registration as BMBS to avail of benefits and incentives provided by the law. Now, if we break down the procedure for registering as a barangay micro business enterprise and the incentives available, you have to visit the local office of the municipal or city treasurer, fill out the BMBA Form 1 and submit it. The application is evaluated within 15 working days. So now, upon approval, a certificate of authority is issued, valid for 2 years and renewable. Incentives, we have incentives for BMBS includes exemption from income tax on business income, encouragement for LGUs to reduce or exempt local taxes, exemption from minimum wage law coverage, while ensuring employee benefits like social security and healthcare. These streamlined procedures and incentives aim to support micro business growth and encourage entrepreneurship in the Philippines. Now, in conclusion, understanding the laws related to tourism, investment, and finance is crucial for setting up and operating tourism-oriented business in the Philippines, from the Foreign Investors Act of 1991 to specialized laws like the Barangay Micro Business Enterprise Law. There are regulations and incentives designed to promote both local and foreign investments in the tourism sector. By navigating these legal frameworks, business can maximize opportunities and contribute to the growth of the tourism industry while ensuring compliance and sustainability. So I hope that masabtan ra, and that will be all for my topic. Thank you and God bless.